can see the screen near me? Oh my God. Okay. Wow.
We'll get there.
That was the scariest part of all of this for me. So I do want to, we're missing the first slide, but it wasn't that important anyway. We're going to talk about sex offender registration and notification laws. This is a population that we've had a very, very challenging time helping, because the sex offender registration laws required lifetime registration for just about everybody. And in order to not be distracted by my email, I'm going to get rid of that. So now it's just you guys and me. So I'm going to share just a little bit more than you probably ever wanted to know about sex offender registration, but it's important to understand it because you're going to see that there's a lot that it's really difficult to actually comply with this. And it's really difficult to do it perfectly. And it's really difficult to do it for these periods of time that we're going to talk about. So before we get into the relief, I just kind of want to go over with you a little bit about what sex offender registration really entails. The person has to register, don't write this down because you don't need to remember any of it. But just to give you a sense, the person has to register within 5 days of their birthday every year. They have to also register within 5 days, within 5 days of any release from custody. So if they're arrested and then released, they have to register again within 5 days of release, even if they already did it on their birthday 2 weeks ago, but they have to. If they change residence, if they move, then they have to register whenever they change residence. If they have a residence and they establish a secondary residence, they have to register that secondary residence within 5 days. If they enter or leave a jurisdiction where they establish residence, meaning they move to a new place, a new city, a new county, they have to register that with the law enforcement officials there within 5 days of entering, and they have to register with the former law enforcement within 5 days of leaving. And then if they become homeless, they have to register within 5 days of becoming homeless, and then they have to update their registration every 30 days thereafter, unless and until they establish a residence, at which time they have to register within 5 days of establishing a residence, and don't forget, register within 5 days of their birthday every year. So I'm telling you this because it has gotten a little bit out of control, and the purpose of the law seems to have been kind of swallowed up by all of these onerous burdens that very few people who are required to register can actually fulfill. And so there, not only did they have all that to do, but the Megan's Law website, which came into being in the mid 2000s, actually, I think it was 2004, that created a stigma and a public shame aspect to being a registrant that hadn't previously existed in California. So with the Megan's Law, and I'm sure that many of you have looked at the Megan's Law website in your areas, it's not uncommon. I just think it's very important to realize that the information that is on the Megan's Law website is very non-inclusive, meaning there's a lot about the person that you may not know. You may not know what year the crime occurred. You may not know how old the person was when the crime occurred, whether they were, 18. You may not know what they've done. You won't know what they've done in a positive way in their lives ever since, and you won't know anything about whether they're at risk to reoffend. So we do tend to view people on the Megan's Law website very, very dangerous, but we may, if we really learn about it, we'll actually realize that they are not, in fact, and I'll get to that at the end of the presentation. Other consequences of being a person required to register. These individuals are subject to coordinated law enforcement task forces, folks that do audits to make sure they are living where they say they're living, do community notification. They'll paper flyer a community when a person who's required to register moves in, and that can result in harassment and vigilantism. It is not uncommon for them to be victims of violence at the hands of neighbors as a result, or the community as a result of this sort of papering. There are state laws and local ordinances restricting where they can live and where they can be present. Unemployment obviously is going to be a huge consequence for a person who is required to register, and that can be for life. Along with unemployment, chronic unemployment is going to go a host of other problems, as you can imagine, that come along with being unemployable and denied of any licensure. They're excluded from almost every community-based resource and service in the state of California, which is where I practice and where my area of expertise is, including homeless shelters, drug and alcohol treatment programs, and licensed mental health placements. So, and they're ineligible for affordable housing subsidies. So it's not uncommon for people who are required to register to at some point in their life, and maybe for a long period of their life, and maybe for the first time in their life, homeless. So that was this has been a real challenge, I think, that we have faced as Californians who are interested in reentry. Is Penal Code Section 290 registration really lifelong? So that's what we're going to talk about today, although I wrote the wrong, I see a typographical error on my slide, so that's fine. Right now, it is not necessarily lifelong for everyone. This is kind of important. So I'm going to tell you who it's not necessarily lifelong for. Registration is not necessarily lifelong for a person who's included in the registry because they were convicted of a misdemeanor offense that requires registration. A misdemeanor offense is something that's punishable by no more than 364 days in county jail. Often a misdemeanor is punishable by up to 180 days in county jail. Those folks are eligible for relief from the duty to register if they successfully complete probation and they obtain what's called an expungement, which is a dismissal under Penal Code Section 1203.4, and they apply for something called a certificate of rehabilitation, and that serves as an automatic governor's pardon, or actually application for governor's pardon. And all of that has to happen by July 1st of 2021 for people to be eligible for relief under this particular mechanism. For all of those people, there is something called a minimum period of rehabilitation. It's either 7 or 10 years from the date of sentencing or the date of release from jail. And so we do have a lot of people right now in California who are eligible for that relief, but some of them will not be eligible for that relief come July 1st of 2021. So this is the one bad thing about SB 384, is that it did not leave in place that existing mechanism for relief. And for those of us who do post-conviction work in this area, it really put us under the gun to assess and get the relief for the folks who are currently eligible, but who won't be eligible on the operative date of the new law, which is July 1st of 2021. So that's a big group. The second group that registration is not really lifelong for is juvenile offenders. There is actually a penal code section that deals with individuals who were tried as children, prosecuted, they were dealt with by the juvenile court. They didn't have a right to a jury trial. They weren't looking at going to prison, and they admitted allegations that they did something while they were a kid, and they were placed on probation, and they did not succeed on probation because, as we know with kids, they're often the victim of their circumstances. And if there's no one driving them to the probation office and no one's making them go to school and no one's home, then often those kids are not successful on probation, and they ended up at what is now called the Division of Juvenile Justice, or DJJ, and previously was called the California Youth Authority, or CYA. Kids who went there for those juvenile offenses and were honorably discharged from the Youth Authority, DJJ, okay, meaning they went out on parole, they did well on parole, they were discharged off parole, and they were honorably discharged. Those kids are all eligible for relief right now. And there was nobody was getting relief for these kids till about 2009. So what that means is there was a disconnect between the Department of Juvenile Justice, CYA, and the Department of Justice, the Attorney General's office, and the juvenile courts. So there's a whole lot of people out there registering who were honorably discharged, but since these people don't know they were honorably discharged because nobody told them, they're still included in the registry, and they've been included in the registry since they were children. So that's another group that we really need to kind of think about when we're, at least I feel we need to think about, they continue to be eligible for that relief instantly. All it takes is a notification to the Department of Justice and a copy of the discharge paper. It's like a certificate. You can get it by contacting DJJ Master Records by fax. They'll send it to you, and you can just email it or fax it to DOJ, and they will instantly terminate that person from the registry. There's also a bunch of folks who were assessed as having to register because of convictions that occurred outside of the state of California, either in another state or sometimes even in another country, or a military adjudication. They were recruited into the military, they went to boot camp, they were young, they were dumb, they were drunk, and they did what young, drunk, stupid people do, and now they have to register for the rest of their lives, right? So those folks may or may not have to register. The problem is nobody's assessed them, meaning no lawyer like me has actually looked at it and made a determination as to whether they really in fact do have to register. What really happened is someone told them to go to the police department and register because they believed that they needed to, and that person wasn't an attorney. And they did, and once they're included in the registry, once that first registration event happens, they remain in the registry. They go into the Violent Crimes Information Network, which is called VCIN, and they stay there forever until someone like me, they come across my desk and I take a look at it and I send something to the Department of Justice asking that they assess it. So there's a lot of those folks. They're eligible for relief. You just have to get the records and demonstrate that they don't have to register. And that is something that probably is more appropriate for an attorney to do. And then there's this group of non-forcible sex offenses that occur in correctional settings, in jails or prisons. They're consensual, but they take place in a location that we don't want people, I guess, engaging in consensual sex. So those cases, those are statutes which the Court of Appeal has determined does not require registration in California, even though those people have been required to register under a statute. The courts have said, no, you can't make them register for that. Again, that's something that needs to happen usually through an attorney doing what's called a petition for writ of mandate in the superior court of the jurisdiction where the person resides. So they would need a lawyer for that. And then we've got this great new law, which is not that great or that new, but we're going to call it that today. And this is where my typo is. I actually gave it the wrong name. Those who are entitled to relief under Penal Code Section 290, Subdivision C, Subdivision 2, as amended by SB 384. So by 245, I mean 384. And that actually, I shouldn't use the word, it became effective on January 1st of 2021, but the certain provision we're going to talk about becomes operative, meaning it goes into operation in July. Oh no, I'm actually right. That's not a typo. That's a whole different bill. Okay, sorry. There's this group of offenses that we used to call H.I.R.E offenses, and they're sort of Romeo and Juliet offenses. The idea being that in California, if an 18-year-old and a 16-year-old have intercourse, it doesn't require registration under California law. But if the 18-year-old and the 16-year-old engage in any other kind of sexual act with one another, so penetration, oral copulation, or sodomy, then it does require registration. So by virtue of what goes into what, that's how registration is determined. And that was found to be unconstitutional in 2006 in a case called People versus H.I.R.E. And then the Supreme Court reversed that case in 2015 and said, no, we were wrong. It's constitutional. It's fine. And so all those people who didn't have to register then had to register. So SB 245, effective January 1st of 2021, changed that. So those people do not have to register so long as the defendant and the victim, so the adult and the minor, were not more than 10 years apart in age, and the defendant has no other convictions for any crime requiring registration. So that is automatic relief. And I am assuming that the Department of Justice is actually assessing all of these people because they've known since the governor signed this bill that it was going to become effective January 1st. And that those folks are just going to be notified that they've been terminated. So those folks, I still haven't even gotten to the topic here, but I'll keep going. So there's actually one other group that I didn't put on that list, and I don't know if it's official, but I think I can say it. Juvenile law changed recently so that children who are under the age of 14 when a crime is committed cannot be sent to the Department of Juvenile Justice for their offense. They can't go to the state facility because they're too young. And so I've seen some terminations happening by the Department of Justice for people that were 13 or younger when their crime I mean, because they're children, the victims are children. So when those acts occurred, those folks I'm seeing being automatically terminated. And while it's not public, my guess is that that's something that the Department of Justice is doing to comply with the change in the law. Okay, so now the big group that we've been forever thinking, gosh, there's no hope for them ever. They're going to have to register for the rest of their lives. And I will tell you, like, law enforcement go to nursing homes and they register people at the side of their bed. I mean, there's no end to this. They're in hospice and the police are coming out to register them. So it doesn't end ever. So this is a very big deal that this is the third bill that went through the California legislature in a period of about 5 years, trying to change our registration law so that it wasn't lifelong for everybody. And there were a lot of different versions of the bill, some of which dealt with risk, risk of reoffense, but we ended up with this one, which does not much deal with risk. It is primarily based on the crime of which the person was convicted, which has no bearing whatsoever with the risk of reoffense, but this is our law. So it's easier to do it this way, I guess. So this is how we're doing it. It has tier assignments for people. So now every person required to register is going to be put into tier 1, tier 2, or tier 3. Tier 1 is a 10-year minimum mandatory period of registration before the person can petition for relief. Tier 2 is 20 years, and tier 3 has no potential to petition for relief. However, so this is when I said to you before, the certificate of rehabilitation thing is going away July 1st of 2021. There are people right now in tier 3 who are eligible for relief through a certificate of rehabilitation because they were convicted of a misdemeanor offense of a crime listed in tier 3, and they've made it 10 years without reoffending. If they don't get relief by July 1st, 2021, they will never be eligible for relief for the rest of their lives. So that's a big deal. And that's why, it's important that we figure out where we can dilly-dally and where we cannot. And yes, I said dilly-dally, so there. I'm from Ohio. Okay. When does this matter? It matters now. The bill became effective January 1st of 2018, actually, but the termination provisions don't become operative until July of 2021. And then there's also a provision that deals with Megan's Law website that becomes operative a little bit later. And because everything that has to do with registration applies retroactively, we need to know about this since January 1st of 2018. But we certainly need to know now. So when we're looking at a person and we're trying to figure out whether or not it is possible for them to get relief, there's 4 questions that we need to answer. First, we need to know what tier do they fall into? And for that, we need a route sheet, and it needs to be a current one. And that means we need a live scan, okay? We can do it with court records, but a live scan is the best way to do it because court records may not show us everything we need to know. The second question we have is, what is that tier's minimum period of registration? Is it 10? Is it 20? Is it forever? The third question is, what are the Megan's Law posting requirements for that tier? Meaning, are they a no post, meaning that they're not on that Big Bad Wolf Megan's Law website? Or are they a limited post, which is the tier 2 people, or are they a full post, which is the tier 3 people? And then what, if anything, stops that period of registration from running, right? So tolling means we're moving along, we stop and we sit and we wait, and then something has to happen before this keeps going, okay? And what extends it, meaning if it's 10 years and it's going to go on beyond 10 years, what makes that happen? And has that happened? Which is another reason we really want that rap sheet. I'm going to explain the tiers to you. This is not how you're going to do your analysis. You're actually going to do it backwards. You're going to start with tier 3, and you're going to figure out whether or not the person is in tier 3. And if they're in tier 3, you're done, okay? If they're not, you're going to go to tier 2, and you're going to say, do they fall into tier 2? And if so, then you know where you are. And if not, then you go to tier 1. But in explaining the tiers to you, I'm going to do it chronologically because the other way makes my brain hurt. I tried to move the slides around so I could start you with tier 3, and my head actually exploded. So I don't want to do that again. So we're going to do it this way. So the people that are in the lowest tier are your children, the 602 wards, the ones who never were convicted in adult court, but actually became registrants because they were true found in a petition was found to be true in juvenile court, and they were adjudicated a ward of the court, and they were committed at some point to the state facility. They are tier 1. There's an asterisk there because there is one offense, one juvenile offense that is tier 1, but only 5 years. And that's the crime of lewd act on a minor. I got to tell you, I don't think I've ever seen a minor, a child, adjudicated a ward based on lewd act against a child, because people don't prosecute that. So if that person exists on the planet, and if that person was committed to the Department of Juvenile Justice or CYA, his or her minimum period of registration is only 5 years, unless he was honorably discharged, in which case he's already done. We just need to notify DOJ. That's for those of you who were paying attention before. Okay. Who else is in tier 1? People that are convicted of misdemeanors listed in subdivision C of 290. So there are this chunk of mandatory registration crimes. Some of them are misdemeanors only. If it's a straight misdemeanor, those folks are in tier 1. However, there's also a provision of law that allows you to take a felony and reduce it to a misdemeanor by the judge at sentencing or by the district attorney at the time the case is issued. Those misdemeanors, if their offense is tier 3, they are not eligible for tier 1. They're in tier 3, even though it's a misdemeanor. That may change with subsequent changes in the law. This is my light going off. Oh, I don't care. The third group in tier 1 is the discretionary registrants. These are people that were not convicted of any crime that requires mandatory registration. Rather, a judge ordered them as a consequence of some other crime to register. They're in tier 1 unless they're in a higher tier. So I'm not going to say unless they're in a higher tier next to every single one of these bullet points, but if you can just hear it in your head, unless they're in a higher tier, that would make this a lot shorter of a presentation. Okay, those convicted of a felony listed in subdivision C of 290, which is not a strike offense. You guys have heard of the California 3 strikes law, serious and violent felonies. They're actually listed in 2 sections of the Penal Code. A felony that's listed here is a violent felony. A felony that's listed here is a serious felony. Both lists are strikes. Those felony strikes are going to be in tier 2, if not higher. Okay. But if it's not in tier 3 and it's not a strike, and it's not taken care of by SB 245, which I talked about on the previous slide, then those folks are going to be in tier 1. Tier 1 is the best tier for sure. There is no Megan's Law publication for tier 1 offenders, except if they were convicted as an adult of misdemeanor annoying or molesting a child, then they are now going to be posted on Megan's Law. Now, that's a very big deal because from 2004 until now, those folks have been eligible for exclusion. They have not been posted on the Megan's Law website. So you're going to have people who've been living in the community for 12 years with no reoffense, who are all of a sudden going to be on the Megan's Law website. And that's going to cause significant problems for them and their families for a misdemeanor. So fortunately, they are tier 1, but they will be on the Megan's Law website. No juveniles on the Megan's Law website unless they were convicted in adult court. And even then, I'm not sure that they actually are. Tier 2, not a lot of people in tier 2. Tier 2 is people required to register for a serious or violent felony that does not put them in tier 3. Okay. Incest is tier 2, 20-year period of rehabilitation. Incest is rare. Incest offenders statistically reoffend at the lowest rate. Juvenile offenders also very, very low rate. Sex offenders generally very, very low rate, but of that very, very low rate, which is less than 5%, incest offenders and juvenile offenders reoffended at a very low rate. There's lots of reasons for it, but the bottom line is that the statistics speak for themselves. So if they've gone 20 years without reoffense, they're eligible to petition. Most felony sex crimes committed against that's not any victim incapable of consent due to a disorder or disability. So we're not talking about forcible sexual acts. We're talking about sexual acts committed that are considered non-consensual due to the victim's cognitive capacity, really. They're in tier 2. Felony, lewd, and lascivious act against a child is in tier 2. And some people with out-of-state convictions or military adjudications are going to be in tier 2 if their offense is not comparable to a mandatory sex registrable offense. So bottom line is this: people with out-of-state convictions are complicated. There's really only 2 ways they can be included in the registry. One is they were ordered to register in the jurisdiction where they lived, or they're required to register if they live there now. That group can be in tier 2, so long as, actually, period, they're into tier 2. The other group's required to register, not because of what would happen in their other jurisdiction, but because the crime they committed there compares to one of our mandatory registration crimes here. And if that's the case, then they're going to be wherever that California crime is. So if that California crime is in tier 3, that's where their registration requirement's going to be. If their California crime is in tier 2, that's where their registration requirement's going to be. A really good example would be federal child porn. There's a lot of prosecutions in federal court for possession of child pornography. In California, that can be punished as a misdemeanor or as a felony. If it's a felony, it's tier 3, lifetime registration. If it's a misdemeanor, it's tier 1, 10-year registration. In federal court, it's going to depend on the sentence. So if a person's sentenced as a felony, it's going to be tier 3. And if it's sentenced as a misdemeanor, it's or less than the mandatory suggested sentencing guidelines, it's tier 1. So it's complicated. But that's the first step, is what tier are they in? And you can't do that without a rap sheet. Tier 3 is a very big list, very big. I'm going to show you how big this is. So any offense listed in subdivision C of Penal Code section 290, where there's a prior violent felony conviction resulting in registration, sure, lifetime. Sexually violent predator, 1-strike sex law, mentally disordered sex offender, not guilty by reason of insanity, lifetime. A person with a risk assessment score of well above average, that's something that's based on static factors that exist at the time that they're released from custody on their sex crime. It cannot change over time, well, except for to get higher. If they're well above average, they're going to be lifetime registration. There is an asterisk there because if that's the only basis for their inclusion in tier 3, if that risk, they can petition for relief under tier 2, but there's got to be a showing of something, and I don't recall right now because I can't see my notes, so sorry. Out-of-state convictions and adjudications comparable to a tier 3 offense, sure. And then we have the tier 3 offenses. And I'm going to go through them super fast because it's what you'd expect, right? Murder, kidnap, assault with specified intent, rape, sodomy, penetration, felony sexual battery, pimping, pandering, human trafficking, forcible sex crimes against a child, internet sex crimes, luring crimes, felony child porn. It's a really, really long list. So that's why we start with tier 3 and say, is the crime on this list? And if it is, you're done for the most part. I've asterisked the things here that can be punished as misdemeanors. The folks I told you about who are eligible, may be eligible for relief until July 1st of 2021 and thereafter will never be. These are crimes that can be punished as misdemeanors, and these folks could have pled guilty to them as or been convicted of them as misdemeanors. They are now going to be tier 3. 288A is lewd and lascivious act against a child. I have 2 asterisks there because there is an exception if the adult and child are close together in age, and that can put the person into tier 2, allowing them to petition for relief after 20 years. I can't even begin to tell you how long 20 years is for a person required to register as a sex offender in California. I will be so stunned when I meet someone who actually gets relief with the 20-year tier, because that means that the person actually complied with all of those requirements while virtually unemployable, unhousable, and completely unsupported, and having all of their information on the Megan's Law website. I just can't imagine, but So to me, tier 2 and tier 3 are sort of the same thing. Tier 2 is like the unicorn. Tolling and extension. Yes, there are things that can be done after a person is convicted or of a sex crime that are going to make their tier longer, their period of rehabilitation longer. Any period of incarceration, placement, or commitment that results in a conviction, an adjudication, or revocation of parole or probation tolls the running of the period of rehabilitation. In other words, anytime they're locked up is going to stop the time, this clock stops ticking and it doesn't start again. Thank you.
Hi, Claudio.
Hi, Claudio. Could you please mute your mic?
Yeah, I'm good. How are you?
Bethany, can you mute? Or I think
What's
you can
the
mute
weather
her.
like where you are?
If you
I
click
can
on
mute.
her. Yeah, click on the ellipses.
Someone text her. What is the name?
On
What do you
Bethany
mean?
Negative one?
Jones.
Bethany Stone.
Oh my
Jones.
goodness.
Listen, this is so much fun. Hold on. Bethany Stone. Bethany Stone. Bethany. Oh, there, Jones. Got her. Yeah, we're gonna mute her. Oh, she did it.
There you go. I just text her.
Oh, thank you. All righty. So anyway, that tolls the running of it. Any conviction for violating any provision of the registration law. Remember, I went through that at the beginning about the birthday and homeless and all that. That extends, if it's a misdemeanor, it'll extend the minimum period of rehabilitation by 1 year. If it's a felony, it extends it by 3 years. So just because we figured out the tier and how long that is, we have to do another level of assessment and figure out what time has that clock not been ticking and what's extended it. So there's that. Megan's Law for tiers, I think I told you that already. Procedure for termination. So there are forms that are going to be provided by the Judicial Council, and there's also instructions on those forms. It's long and it's complicated. If this presentation for you wasn't long and complicated enough, wait till you get a hold of those forms. Boy howdy. So we didn't do it on purpose. Unfortunately, if we have a long and complicated statute, we have to make long and complicated forms. But here are the rules for termination. As now we've assessed the person and we've determined that they are eligible for relief. First of all, they have to be living in California at the time the petition is filed. So if they've moved out of state, they have to relocate if they want relief. Secondly, they can't be in custody or on supervision for anything. They can't be on parole, probation, mandatory supervision, anything like that. They can't have any pending charges, and that's going to be tricky because they may not even know if they have pending charges. So hopefully you'll have that current rap sheet, which might be able to help you. Otherwise, they're just going to have to check warrants in any place that they've driven through or live to make sure they have no pending charges. The petition has to be filed in the county, in the Superior Court where the person lives. And it has to be supported with proof that their registration is current, which is something that they will have to get from the law enforcement agency where they register. It has to be served by mail or personal service or email if that's accepted in your jurisdiction on the law enforcement agent, every law enforcement agency with whom the individual registers, and the investigating law enforcement agency, which is whoever did the underlying investigation in the criminal case that occurred 10, 20, however many years ago, and the district attorney in the county of conviction, not the county where they live, but the county where they were convicted. After the petition is filed, the law enforcement and DA will notify the court as to whether the person meets the minimum requirements for termination. The DA can request a hearing to oppose the petition. If no hearing is requested, the petition must be granted. And if a hearing is requested, the court must receive evidence and then determine whether community safety would be significantly enhanced by requiring the person to continue registering. And that evidence can be in the form of police reports and other types of inadmissible hearsay. It can also be letters from from people that know the individual in the community and have known that person for 20 years and worked with that person, or been married to that person, or been the parent of that person, and have something to say about how they've changed and the person that they've become, if the 20 years of compliance doesn't speak for itself. If the petition is denied, the court has to set a time period after which the person can petition again. It can't be more than 5 years, can't be less than 1, and has to state why. Here are some popular myths or findings that have been allegedly made by our legislature in the past. And I'm going to talk to you about this because this is my passion. I really don't like ignorance. It makes me angry. So I need to make sure that myths are not taken as fact. And so every time I get a chance to speak to normal people, which is what I was told you guys are, I take the opportunity to share with you information that may not be available to you on social media. So the first myth is that sex offenders are more likely to reoffend than are other types of criminal offenders. That is false. According to the Department of Justice and the California Department of Corrections and Rehabilitation and California's Sex Offender Management Board, it is established that sex offenders are considerably less likely to reoffend than are any other type of criminal, except people who commit murder. Okay, apparently people who commit murder only do it once. Sex offenders are right there. So if they're gonna screw up, they're gonna screw up big, but they're not gonna do it again. I'm not saying that's good. I'm saying that's the science. Sex offenders prey on unsuspecting strangers, especially innocent children. No, many people required to register in California have never committed any crime involving a child or any hands-on sex offense. I mean, they've never touched anybody except themselves. Okay. With regard to child victim cases, we know that approximately 80% of sex crimes against children are committed by someone who has a pre-existing relationship with them. Mom's boyfriend, an uncle, a soccer coach. That's the people that we leave our kids with. Those are the people that we need to be concerned about, not the people on the registry. Convicted sex offenders pose a substantial risk to public safety. Also false. According to Department of Justice statistics, only 13% of all sex crimes are committed by people who have previously been convicted of a sex offense. That means conversely, 87% are committed by people who are not on the registry. So we're putting all these resources into this registry that tells us a bunch of people that probably won't reoffend. and we're not putting those resources into doing the things we need to do to actually protect our children from the people who are likely to offend against them. Restrictions on where sex offenders live protect the public. False. According to law enforcement, treatment providers, and victims' rights groups, residency restrictions do nothing to promote public safety. Rather, what they do is they drive offenders underground, substantially decreasing the accuracy of registries. They cause offenders to become unstable economically, socially, and emotionally. They drain valuable law enforcement resources, and they actually increase the risk of recidivism. That's just the science. That's all